Thank you very much for being here, and I'm very happy to meet you. And really, I have good memories of quite long-lasting cooperation in terms of environmental law. And as it has been mentioned earlier, that I am acting in two positions already for more than 40 years when I started to teach environmental law, and now I'm still working at the Catholic University. And I had the pleasure to be elected by the Parliament in 2017 February to be this to serve in this very special position. And that's the reason why when we could talk about the possibilities that what can be an interesting topic for your wonderful series, because I'm also circulating this idea on our Facebook profile, that as far as I know, many people could already use this set of lectures which you are providing for the people. So congratulations, first of all. And then my idea was that it might be interesting to speak about what is what is this future generations ombudsman position, what we are doing, why we are doing that. So if you don't mind, I try to give you some kind of general introduction into the topic and how this idea has been developed, not only in Hungary, but in a wider context. And then, of course, I would like to cover issues that what is our position, what is our role, what are those tasks we are responsible for, and also then later the activities, some examples, some cases. Probably it might be interesting. And this is, as it has already been mentioned, I'm the Deputy Commissioner for Fundamental Rights, and I have this special position within that. It's an Ombudsman for Future Generations, and you will see why it is, what is the background, what is the history. So let's start with the concept. I do not want to go back to the Brundtland report and the Rio declaration, but I just quote one paper, Barra's paper, who says that most of the real content of these documents, these two documents, Brundtland and Rio, shows that the meaning of sustainable development can be reduced to the combination of two principles that can be seen as axiomatic to understand sustainable development: intergenerational and intragenerational equity. Later, she also adds the problem of integration as a third concept. But it is quite interesting that everywhere when sustainable development is mentioned, that these two types of generational equity are also covered. And if we want to understand that how it works, then it is good, and how it has been developed, we should go back to the theoretical basis. And here the best way is to use Edith Brome-Weiss's papers, who might be taken as the, it is not too polite to say that the mother of the idea of sustainable of future generations, but I hope she does not mind. So according to her classification, there are three major principles in connection with intergenerational equity. First, to conserve options, diversity of choice. And what is very interesting, that later I will go to the question of explaining the current practice of the Constitutional Court, and they are also using this three-fold principles in their decisions. So they are clearly quoting Edith Bromweis's classes. So conserve options, diversity of choice. And of course, everybody knows that future generations, which is written here, that are entitled to diversity comparable to that which has been enjoyed by previous generations. Frankly speaking, it is a wonderful principle, but I don't think it might work. That we will have the same options and then the same diversity of choice, but this is just in brackets. Then also it is a second question to maintain the quality comparable. This might work probably, that comparable to which has been enjoyed by previous generations, which means it's not the same, unfortunately. And also then they must have access to different things. For example, which is a very big challenge nowadays is, for example, to water, to drinking water and supplies. So this was the starting point, which I just wanted to mention, and there it comes the problem that actually what is the possibility, how it can be solved to put this different generational activity, intergenerational activity into practice. Does it mean that we have we have to create some rights of future generations, and we should create some idea that what these rights should cover, and then it means that everybody might question that, okay, how should we know that what 50 years later what people would like to have? And this is a very good way of making several legal scholarly works, but it does not necessarily mean that we are coming closer to the issue. So it is another possibility, and that is how many people and many institutions are working in that way, that not to focus on what are those requirements, what are those low rights actually of future generations, but to see what are the obligations of the current generations and how these obligations might be met. So what are those institutions, what are those means and methods which might serve this obligation of the current generations to provide some rights for future. If we go on, then I just want to mention two things. One is probably many of you know that there is a think tank, of the global think tank, which is the World Future Council, and this World Future Council has some papers also on this kind of institutions of future generations. It is you might find it on the internet. It's there is a wonderful leaflet, and among others, I will come back to it later. We also refer to our institutions, and they say that the best way could be to have a kind of guardian for future generations, and it has been raised, for example, during the preparation process of the Rio +20 before 2012, and it was the idea to accept some kind of global level guardian position or guardian idea, but finally it did not come to reality. It did not reach the level of the conference. It has been somehow cancelled even before the Rio +20 conference. But this World Future Council says that what are those obligations, or what are those responsibilities of such kind of guardian. It doesn't say that which kind of guardian it is, but according to this summary, they clearly refer to an ombudsperson-like institution, and they say that this ombudsperson conveys citizens' concerns to legislating units. Also, it is an interface to look at the incentives for this integration, which is, we mentioned already that it is an essential part of the sustainable development idea. This guardian might serve as a kind of advisory body which is recommending solutions, and also it might serve as an auditing body of what has been done in government level and in reality. And that is what I mentioned again, that so instead of discussion the rights, we have to clarify the obligations of current generations. As it has been mentioned that I'm working at the Catholic University, so I hope you forgive me that I'm quoting Pope Francis. I hope many of you know this wonderful encyclical Laudato Si, which is 7 years old, and which says that the natural, for example, among others, that the natural environment is a collective good, patrimony of all humanity and the responsibility of everyone. This is very interesting because the same idea later comes up in the Hungarian fundamental law, or in more general terms constitution, that to protect, preserve these values should be taken as the responsibility of everyone. And also he underlines that this common good also extends to future generations, and intergenerational solidarity must be a very important part of this idea. I mentioned this encyclical, and I might mention anything else, but the Catholic Church is, in that respect, has a easier position because they have a pope, and so they have an authority, while many other churches have smaller authorities, regional authorities. So then this is converted into an encyclical. So it is very interesting, very important, because in any way, not only the church or many other churches, but the lawyers are also talking about the necessary ethical background of this concept and the necessary ethical background of this idea and this future generations question. So now I would like to turn to the Hungarian example. So how it has been done. We should know that as you can see, in 2005, discussion started about the idea how to have this, how to create this kind of guardian. At that time, it was not clear that what should be done. And at that time, President of the Hungarian Republic, László Solyom, who is very well known in these green movements. Even earlier, he participated in the Danube movement, which all led to the Gabčíkovo-Nagymaros case, according to the dam on the Danube. And several NGOs also participated. And I remember these discussions. We had meetings, and there were questions that how to come closer to the problem, what are the best ideas. And it ended up to an act, actually a draft first, and then an act, which has been adopted 15 years ago, at the end of 2007, this time it established this Ombudsman for Future Generations, who started to work at the beginning of the coming year, so 2008, and this time it's proved to be an independent ombudsman, and as you can see, with a relatively big staff. So it was at that time that we had several individual ombudsmen, ombudsperson positions. One was the general, one as the future generations, then minority rights, and then there was one for data protection, which now is turned to be an authority today. It's an authority, separate national authority. So it was a good idea. It's very interesting that to mention something connected with politics, that the current governing party at that time was in the opposition. So they really, if I might say, they really liked the idea to establish a kind of institution which is controlling the public administration, controlling the government functions, and it is a useful concept according to that time opposition party. I will tell you why I mention it, because as you can see later, it has been a bit changed. As at that time opposition party was converted to the governing party, they also changed the idea of how useful this authority is, but it is just in brackets. So the ombudsmen are elected by a 2/3 majority of the parliament, so it requires a relatively big support of the political parties. Practically today, as probably you might know, that since 2010, the current government has a 2/3 majority during the last 12 years in the parliament, so they can decide on their own without any kind of agreement with any kind of opposition. This is just a very practical question. So in 2000, very soon after the changes of the government, the current governing party decided to renew the constitution, and even the name was changed, that fundamental law of Hungary, and because they wanted to prove that it is something absolutely different. And it was easy, because with a 2/3 majority, you can change, rewrite actually the constitution. And immediately it became clear, if I might be a bit critical, that those too many and strong control mechanisms which are provided by the different types of ombudsperson, that it is not necessarily useful for the actual government. And therefore they decided, of course from practical reasons and not because of my humble explanation, so because of practical reasons, that it is better to have one big office of ombudsman. Even the name was changed, Commissioner for Fundamental Rights, and to have 2 deputies. And since that time, the data protection, according to the European rules, has been developed as a separate national authority. So the fundamental role is structured, and also the act on Commissioner of Fundamental Rights, which has also been adopted by the same year, provided the details. So then the current situation is the following, that the Commissioner for Fundamental Rights has 2 deputies, one for the protection of future generations and other for the protection of national minorities. With, at the beginning, it was an absolutely huge change that they cut seriously the staff. And of course, they cut seriously the powers. If I might say one example, the individual ombudsman might turn to the Constitutional Court by him or herself, but a deputy might do this the same only via the commissioner. So the individual ombudsperson had the right to be also to enter into judicial proceedings as an interested party, but the deputy might not do it. Only the commissioner might do it. Also, when we have opinions of different legal drafts, then the commissioner is addressed with this on behalf of the parliament or the government, and not the deputies. And so we have a much less clear and strong powers. In brackets, that was the reason why as the ombudsman are elected for a 3-year term. That was the reason why the first ombudsman, who started as an individual and then turned to a deputy, stepped down, and after 4 years, and there was a new election with my predecessor, who later became a constitutional court judge, and that was the reason why I was elected in 2017. So this is about the practical questions. So the predecessor and also myself could work on establishing somehow the professional background and the necessary staff background of our activity. As you can see, that for a while there was a secretariat of 9 persons, and then in direct professional guidance we have 7 more, which means that they were responsible for several other things, among others for these ideas of the Ombudsman for Future Generations. And 2 years ago, it was integrated with a relatively smaller team, and that is the current situation. It is quite clear that I will introduce the constitutional mandate in a minute, but it is probably quite clear that while we are talking of future generations, we are speaking about the sustainable development in the background and an ecological questions of sustainable development. So we do not cover everything, which is, for example, mentioned on the UN SDG 17 goals in 2015. But rather we focus on the, how can I say, the green part of it. When I was elected, for example, and I had some interviews by the media, then I was addressed that as the new green ombudsman. So it's not everything which is connected with future generations problems. I give you one example. I receive nowadays even some complaints about educational issues and public education, but we do not have this in our mandate, because the Constitution provides the mandate, and also which is the fundamental law, and also this Act on Future on Commissioner, and within this the future generations. Okay, now what is this mandate? So if we look at the constitutional mandate, then there are those major thematic pillars or in the fundamental role. I have to add that the second and the third, which speaks about the rights, it is not new. Which is really new, it is the common heritage of the nation. So Article P, and Article P is highlighted as the major source of authority of my position. But the other two has already been mentioned. This right to physical and mental health and the right to a healthy environment has already been mentioned in the Constitution since 1989. So they are not exactly new. There are some changes in the wording, but the major concept is good. So before I go to Article P, two more words about these rights. So the right to physical and mental health speaks about the environmental protection indirectly, saying that the right to physical and mental health might be guaranteed through different things are mentioned, through environmental protection. But the right to a healthy environment is clearly connected with the environment, and you can see that why we are taken as green ombudspersons, because of these thematic pillars. What is really interesting, I have to add that also the preamble, which is the national avowal, according to the new wording. So the preamble also covers issues of sustainable development and future generation rights. But the core issue is Article P. As you can see, if you don't mind, I also read it up, that natural resources, in particular arable and forests and the reserves of water, biodiversity, within these native plants and animal species, also as well as cultural heritage, form common heritage of the nation. Of course, you know that the common heritage concept is well known also in international law, that common heritage of mankind. So this is more or less the same idea, but limited to the nation. I have to add that in other, mostly in the preamble, we also speak about the responsibility, in the international responsibility in that respect. So it is not necessarily limited to the nation. Shall be the obligation of the state and everyone, I will come back to it, with the words of Constitutional Court, to protect and maintain them and preserve them for future generations. So that is the core issue, which we should know. There is something which I have to underline, that is that in particular, and as you can see, not everything is listed. For example, climate change, which is a big issue today, or even air pollution questions are not listed, but in particular means that it is not a full and list of everything. So it just highlights some issues. By the way, there are, as I already mentioned, very good decisions of the Constitutional Court, and they also underline that, for example, airport issues and climate change issues also belong to these questions, and in particular is not something which is ended up with these lists. So that's the reason why, in practice, the interests of future generations are understood as issues relating to environmental protection, nature conservation, and what is very important, cultural heritage. I have to add this because poor cultural heritage is always in a very handicapped situation, at least in Hungary. I don't know what is this case in other countries, but in Hungary, they sometimes they belong to there, sometimes they belong to other ministries. So this, like a poor abandoned child, are taken, are mentioned usually, but here it is quite clear that the built and natural environment altogether belongs to this common heritage of the nation. I think it might be interesting. And I also add again that at the same year in 2011, the Acton Commissioner for Fundamental Rights has been also adopted. What are the main functions listed in this act? So I don't refer to the act in details, but there are main functions which I have to highlight. Practically functions of the commissioner and also my own functions, not my, but in the positions functions. First of all, investigating citizens' complaints, environmental related issues or maladministration. So, which is the classical ombudsman issue that to control the public administration, and that anyone might come here and anyone might have questions. There are, of course, some limitations that ongoing issues cannot be touched, or so which is still in the procedure. Of course, when there is a judicial procedure going on, it is also different. We are not able to control the courts of cause and the prosecutors, but the public administration in a broader sense. So even public services and of course local governments and the government and all the attached functions of the government. Also, I might mention that it's a kind of watchdog for any future generations matter, which we deem significant, which means that we can select something on our own. So, for example, just at this weekend, I have something to do because I promised to my colleagues that Monday morning it will be ready. That there is a guidance in connection with the local nature protection areas, and we try to based on our several cases also, we try to provide some kind of guidance that what the local governments and how the local governments should work in that respect. So this is a kind of watchdog. We can have ex officio investigations to explore systemic problems if we need. We might have regulatory proposals on the one way that to commend the bridges, as you can see, as I already mentioned, through the commissioner, but we might have a possibility to initiate legislation on our own, which means you will see some examples later, which we are really doing. So we try to propose changes on legislation or to have something new. Then, as I already mentioned, that through the commissioner we might initiate the constitutional court procedure. Also, there is a possibility to have the same in front of the Supreme Court in connection with the local municipalities, local governments acts. I already mentioned that the possibility to have an intervention in the judicial review, but it is again not the ombudsman's, but the commissioner's authority. By the way, I just mentioned here a decision of the Curia. It is the Supreme Court, but it has been renamed instead of Supreme Court. Now it is called Curia of Hungary. What happened that unfortunately we never used. It is not, as I mentioned to you, it is not my authority. I initiated, and the commissioner decides. And the commissioner does not like this function too much. So although I initiated several times, but what happened? It's very interesting. If I can tell you a story, that a government environmental authority in a case in front of a public law case in front of a court proposed to the court to invite us to enter into the proceeding. The court rejected it. This case went up to the Curia, so the Supreme Court, and in March, the Curia annulled the decision of the court, the regional court, and saying that the interests of future generations are so important that they should have asked the commissioner to join to the case and present the views which are so important in decision making that they cannot be disregarded. And that's the reason that there was an individual decision of the Curia, and the Curia also underlined that even without asking by the parties, the courts themselves should use this possibility in order to get the views in connection with future generations. What is the outcome? It was at the beginning of March, and since today we received 4 different interventions by courts. We are just evaluating them just now because we have to answer and we have to present our views to the commissioner whether to participate or not. So it seems to be that this is revitalized somehow, this judicial review. If we are not able to push it through, but the courts are doing, and the Curia is doing it. And the reason why I talked with the people at the Curia that they really believe that those views which we are representing might be very useful in the court cases. And I think it's a very interesting new challenge which we are facing now, just now. So if this presentation or discussion would have been organized a week ago, then I could not say anything in that respect. It is actually last Friday when they arrived. So also we are providing a neutral platform for negotiations. This is very interesting because we organize, for example, questions, roundtables on circular economy, on consumer protection, advertisement, greenwashing, and things like that. And people are, from NGOs, governmental stakeholders, professional groups, the academia, professional NGOs are coming with pleasure to discuss these points, and we try to formulate some ideas, some outcome of this. One of what we are now working on a proposal, a regulatory proposal on the basis of that kind of negotiations, is the question of how to formulate in legal language the questions of ecological services. We are also permanent invited to the National Sustainable Development Council, the National Environmental Protection Council. I have the right to be heard at different committees of the parliament. Sometimes I am doing it. Also interesting story when the chairperson of the given committee told to me that, okay, they have to ask the members of the committee whether I should be heard or not. But unfortunately, we informed them that according to their own rules, I have the right to be heard. So it cannot be overruled. And then we have a general rephrasing function like media appearances. For example, the current issue, the current time is also a good example that what we mean under general rephrasing. And according to the National Sustainable Development Council, which has a brochure on the major sustainability institutions, which has, among others, the National Bank, who is nowadays is very interested in green banking. We are listed. What are the main legal tools? The individual complaints end up in a joint report. Practically, it is only a practice because, as I told you, the authorities of the deputy position are much weaker than the individual positions authority. So the joint report is just a practice according to the act. It is the commissioner who is reporting, but we could have a practice when that in environmental issues we are signing together. Then there are flexibility. We have a great flexibility in that kind of complex matters which I mentioned, like the ex officio investigations, like the legislative proposals, like to create some kind of general opinions. I already mentioned to you this local nature protection problem that the form might be a general, so-called general opinion to cover the complex systems, to go into the problem, the roots of the problem, and to make some proposals. And we also have different public statements as possibility, which we are using. If you want to see that some example of how it is working, this is the a kind of annual caseload, which might be interesting. As you can see, there are the cases which the whole commissioner office, so the Commissioner of Fundamental Rights received. This is the first column. There are, as you can see, around 6,000 to 7,000 per year. There are those annual cases which are received. And as you can see, FGE, that case is future generations, of course. And as you can see, they are from 5 to 8.5 and 8.5% of the cases are connected to our activities. It might be interesting. Last year, it was the highest number. It was over 600. It means that many people were interested in these issues. And of course, in many cases, we have to refuse the complaint, for example, because, as I mentioned to you, it is in an ongoing case. There was no decision of the public authority, or that is a simple civil law question of protecting connected with trespass or neighborhood rights. And in that case, we always inform the people that what they should do. So we never say that, sorry, we don't have any authority, go home. We always tell them that what to do. And this is a distribution of cases from 2020. This is not absolutely, this is but more or less the same. As you can see, what are generally environmental protection issues, agriculture, and so on. And this is just, it's not so important, but the number of cases probably is very important. So it means that there is a big interest generally. I already mentioned this under this heading, that flexibility in complex matters. So let's turn to things where we try to work on our own. I mentioned 3 legislative proposals here. One is we introduced, and I will come back to them if you are interested. And later I also mentioned them, but I think it's enough because I can see that my time. But tell me when my time is coming to the end. Before that, sorry for that, because I'm willing to go over the time limits. So as a professor, it always happens. So we already introduced a kind of a complex environmental liability scheme, which was, it's a relatively old story. It is from 2019. It means that we could go through different discussions with NGOs, with business associations, with prosecutors, with judges, with legal experts, and so on and so on, with the insurance companies, that how to improve the environmental liability regime in Hungary, the idea was to avoid that the current pollutions become later historic pollutions which you have to solve, because that is always the problem. That first question is that how to solve the problem of historic pollution, but we should avoid that the current situations are not solved and they become again historic pollutions which later they have to solve. Among others, one of the most interesting issues is to use these financial guarantees and how it should be done. Then we have several discussions in connection with the legislation with the groundwater protection. I will come back to it in the Constitutional Court when I go through some cases. Then I mentioned to you that we are now working on the evaluation of ecosystem services and how it should be done. We had meetings, it was organized in the Academy of Sciences with inviting many people. Then we had general opinions that already in 2017, it was one of the first when I was entered into office, that what is the exact role of as sustainable development goals, and how is it connected with the human rights issues and fundamental rights. So why it is really true that fundamental rights protection are always connected with some types of some kind of sustainable development goals, and this is also a kind of educational program for our own office of the commissioner. Then we discussed how to improve the national waste management scheme, how to reorganize the environmental institutional safeguards, because the environmental administration has been changed constantly in the last 7-8 years, with a very special kind of integration, that not the environmental issues have been integrated, but the environmental issues have been integrated to others, and to create one more complex county level public authority system, which was not necessarily good for the protection of environmental interests. Then nature conservation restrictions, landscape planning. Then there are examples for public statements on biodiversity, sustainable city planning, or I already mentioned to you the advertisement, and we have a very good cooperation with the Association of Advertisers. It is not the official wording. I don't know the official English wording. I'm very sorry. I know the Hungarian, but probably it is not helpful. And together with them, we could renew the part on environment in the ethical code for advertising companies, which I think it is not really visible too much, but it is probably a very interesting and important question. Or one of the recent ones is solar panels and soil protection, that we warned the government that this is wonderful that we introduce solar panels everywhere, but then we have to limit ourselves and not to use the best arable lands for solar panels. And if we introduce such a system of support, financial aids and financial supports which are providing assistance for solar panels, it should not work against the interests of agricultural production. We have reports to the Parliament every year. The Commissioner is reporting to the Parliament, and we have a chapter on that. And I mentioned 2 examples of recent questions, which in the introductory parts. I don't want to read it because I think really it is much more important to speak about the interpretation of the constitutional rights by the Constitutional Court. But I think I hope that this PowerPoint presentation might be published, I don't know, and that I will send it to you, of course, and then you can read it. About our mission, I don't want to go into that details. That's what I meant saying it's very, very interesting. That we are working closely with the Constitutional Court, although I personally do not have the possibility to go to the court directly, but we are addressed many times by the court. So if the Constitutional Court addresses the Ombudsman for future generations and asks a kind of amicus brief, so asks an opinion, then we are, of course, answering. There are several examples. The first was this nature conservation. It was practically Natura 2000 areas connected issue when we were asked. Also, in the groundwater protection issues, we worked together with the President of the Republic, who initiated the case in front of the Constitutional Court, and then we sent an amicus brief to the court. It was the same in institutional structure of environmental and nature protection agencies, where we were asked to present our views, and it was only the forestry legislation which was challenged by the Commissioner of Fundamental Rights, and it was prepared. The case was prepared by our team. So this first issue was very interesting because it was the first time when the question of future generations have been clearly mentioned and discussed by the Constitutional Court. So Natura 2000 areas protection was the reason why I had to use this and to go into the discussion of future generations issues. The groundwater protection is very interesting. It is an ongoing case, and we also had several other discussions in that respect with the Agriculture Ministry and with the Parliament, the committees, because they, as you can see, that they wanted to allow wanted to get rid of the authorization. Practically, it is the case that wanted to get rid of the authorization, saying that up to 80 meters, anyone can drill a well. Do you know what was the reason behind that? Actually, we are not able to control this drilling, so why should not we say that then it can be done? Which is, in my mind, it's a very, very how can I say, may I say that stupid idea? I'm sorry to say that, because instead of developing a monitoring structure, they want to open up the borders, which from the point of view of water protection it's a terrible idea. On the one hand, because you are using the groundwater reserves, and also on the other hand, because it might let the groundwater reserve to be polluted through this kind of wells. So finally, it was too much for the President of the Republic himself, and he initiated the case. And as I mentioned, we made a small report, only 30 pages for that. And we asked 11 professional water organizations, so professional NGOs, and we collected their views, and it was all presented to the court, and it was highly used by the court, and we are very proud of it. In case of, I mentioned this special integration, that everything was integrated to a one general administrative authority at county level. As previously the environmental authorities could serve as a standalone authorities, now they are integrated, and then on our amicus brief, the court underlined the problem that even if this has been done, but still environmental and nature protection interests should not be subordinated to other interests. And in the final decision, this one general authority should always mention what are those environment and nature conservation interests and who they are protected. And the forestry legislation, it was very interesting because it was the question of forestry versus nature conservation. According to this whole was initiated by the WWF and the Friends of Earth Hungary to us, and then we made the proposal to the commissioner who accepted it, and it was a very important question because, among others, it was very briefly. So, for example, due to the changes of the forest legislation, if I might give something in numbers, that up till now, 80% of protected areas could serve protection functions, and 20% should serve forest management functions. Due to the changes, it was the other way around. So 20% limited to 20%, the real protection, and for the other part, the 80%, the forest management was taken as the lead. But the Constitutional Court annulled these provisions. Just for lawyers, a very interesting thing that we did not attack the whole act, but we had 32 different very small items mentioned that the court, if the court only delete these one word or two words. So, for example, if you say protected area or you say highly protected area, according to the public, highly is nicer. But if you say that only the highly protected area is protected really, then it is much smaller. So if you simply delete this reference and you only say protected area, then it is bigger. It covers much more. So, and also this very interesting that the court used this public trust doctrine for the first time, saying that state needs to manage the common heritage of the nation for future generation as beneficiaries. I think it's a very interesting question. This Forest Act, which I already mentioned to you, so it is given in details. And one more thing which is very important, that the common interest says this common interest, the public trust, cannot be overridden by any current economic interests of the present generation. And after that, we issued a public statement providing a detailed list of consequences coming from the decision, because the court says that they annulled these 32 points, not everything. Two was not touched, so 30 points. And what's next? And it was the agricultural ministry who was responsible was not interested in explaining that what's next. We took the job and we explained what are the consequences of this situation. Interestingly enough, last year in November, we had a very important meeting with the forest management associations, and we could come to a kind of agreement. I have to mention something about the Constitutional Court practice, because it is in my mind, it is worth to mention, and it is also have a very close contact with our work, and it is from the legal point of view, it's extremely important. For example, precautionary principle. I already told you this Natura 2000 decision from 2017. Precautionary principle has been mentioned there for the first time. Because the Constitutional Court speaks about the regulations of the state, so the legal regulations, this precautionary principle was converted in that respect, that state bears the burden of proof that the condition of environment does not deteriorate as a result of a certain measure. So what is used in precautionary principle, this scientific uncertainty question, it's now converted to the state and turned to the state that, okay, then it is you who have to prove that you did everything and it does not have a significant burden or a significant danger. Then the non-regression or non-retrogression principle has been mentioned by the court from the very beginning. This is very, very important because they say that the level of protection already achieved should not be reduced. And then the court added that it is valid for the material legislation, the procedural legislation, and the institutional structure. So it has been defined. In both cases, for the precautionary principle and the non-retrogression principle, the court underlined that no, they are taken as constitutional principles, as for example, in case of precautionary principle in 2000, at the so-called Artegodan case in the EU, the court, the European court, they mentioned the same, that precautionary principle, as it mentioned in the environmental field, now should be taken as the general principle of the European law. So this happened that the court underlined that they are constitutional principles. They are using necessity and proportionality tests, which I don't have to discuss because the time is, I think it's nearly over. Tell me the truth. I think it is. And what is very important, that the intergenerational equity, the questions of future generations, as I already mentioned to you, they were taken up, and they are nowadays it is absolutely accepted and used by the court. And as I already mentioned to you in the beginning, that those three elements of Edith Bromweis's understanding are used by the court. And clearly the court decision refers to Edith Bromweis and also to the Pope Francis's encyclical, so for the ethical background, which is also very important. They underline that long-term thinking is a must, that the plans and strategies and policies should not be linked to the government structures and the government 4 years time limits, but it should have a much longer vision. And I already mentioned to you this three, that the article P speaking about the responsibility of everyone. And then the court adds that yes, it is the responsibility of everyone, but the primary responsibility is for the state, because if the others are not aware of their responsibilities, then we are not able to implement it. And the state is responsible to create the legal structure, the necessary legal structure, which the others should use. And the public trust doctrine. Some other achievements that I already mentioned to you: sustainable development goals, environmental liability regulation. One more example was the airport noise. From time to time, the people living around the big international airport in Budapest, they have several claims, absolutely legal claims, and we organized meetings, and there were some changes due to these meetings, which we are also very proud of. And I think the time is flying. To conclude, this is a which I wrote in 2018 in this future generations brochure. You can see down there that what is it is all about, that we try to work and function as an official agent of the green consciousness. And I also believe that the small steps taken, not necessarily huge steps, are also very useful and might lead to something good. And at the end, I just want to refer to something internationally important. That nowadays, as you can see, that there are some achievements, of course, you know, And first of all, I have to mention that our activity is widely mentioned in the Special Rapporteur for Human Rights and Environment activities with the general and the European national human rights institutions, associations reference us as good practices. For example, they liked very much our involvement in the voluntary national sustainable development review, because the Hungarian government used our papers in that respect, referring that it is not the government activity, it is our activity. It was presented to UN, and there are some ideas of developing possible model institutions. Probably you know that our friend Richard McCrory in UK is also working as a kind of relatively similar idea as a commissioner. They are setting up a kind of office like this. We were in touch with Richard because the idea was that if UK is leaving the EU, then those control mechanisms which are used by the EU will disappear, and instead of these mechanisms something should be done, and they had this idea, for example, and there are some examples also. As you know that in our Common Agenda report published by the UN Secretary General last September, they also making several commitments for future generations. The UN Special Envoy should be established. There should be a public declaration of future generations, and so on and so on. And of course, it's a very important achievement last October that the UN Human Rights Council finally adopted the landmark resolution on recognizing the human right to clean, healthy, and sustainable environment. We will see what will happen next. I also mentioned the European Convention of Human Rights, the practice of the European Court of Human Rights, which I don't want to go into the details. Also the social charters jurisprudence, which might be interesting. And before I finish, one thing, that there is a network of institutions for future generations. At the moment, we are serving as the secretariat. Practically, New Zealand Ombudsman is there, Welsh Ombudsman for future generations, and a Norwegian for children's rights, and a Canadian auditing office, which have a special role in that, a former Israeli ombudsperson, because after one term, the Israeli ombudsman for sustainable development has been cancelled because he was too active. But of course it happens, and we have this NIFG, so Network of Institutions for Future Generations, if somebody is interested. Thank you very much. Thank you for your interest, and thank you for inviting.